The third is that there are no specifications as to the cost of getting the information. By keeping that undefined, again, is very dangerous because it leaves, it gives you the opportunity to actually impose fees and processes that could actually impede the public right to information. And in addition to the cost not being specified, there is another obstacle in Section 6, which says that when you want to request for an information, you've got to fill up a form. Fine. In that form, you have to say why you want that information. You need to justify the reasons for your requests. Now, we think that this actually is open to abuse, or it can be, because it is then the discretion, is at the discretion of the information officer to decide whether they want to give you the information or not. Now, to make things worse, there is a provision for penalty in the law which says that you can be penalized, it's an offense to give false information. And that is actually making reference to the reasons in the form that you write to say why you want that information. So let's say that I go in and I want to get information about the sand mining thing. Okay, I just say I want to know the number of contracts that were given out to in the year 2008 to 2009. And I say that it's because I think it's affecting my area, I just want to know. Now, you get that information, and as you're reading through that information, you find something else. And then you get shocked finding some other information, and then you may actually tell other people, you may have a press conference and say, oh, this is worse than we thought because blah, 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 blah. And then they come to you and say, but that's not why you asked for the information. So we can actually penalize you. Up to 50,000 ringgit, by the way. 50,000 ringgit and 3 years jail, 5 years. So the offense in the law is very, very much tied to your justification for seeking that information, which is totally contradictory to what we had proposed, where penalties or offenses, we are looking at willful obstruction of giving out information, maybe destroying information. Now, all those are considered offenses. So by preventing someone from giving information, that is an offense. That is what should be taken care of. Not that I asked for reason A, but I actually use it for reason B, and that is subject to interpretation. How do you define those things? So it's very, very dangerous to put in provisions like that. So in our proposal or in our draft, there is no need to state your justification. Again, because it's subject to discretion, and officers should not have that discretionary powers. I mentioned the penalties, which are very much heavily on people seeking information instead of people destroying or obstructing the process of accessing information. Again, it's very unjust. And the last one is the appeals board. The law actually creates an appeals board where if you are unhappy with the decision, where your request is rejected, for example, you can actually go to an appeals board and appeal and say, I want this decision to be reviewed. The setting up of the appeals board is very top-heavy. It's decided by the state. There is no criteria, except that they want to get in some retired judges and things like that. But if you look at the functions of the, not the functions, but if you look at the way decisions are made by the board, you have a chairman and you have 2 other members. The chairman can decide irrespective of what the members have said. So the last final say is with the chairman. That is absolutely unjust. It's totally undemocratic. And you will not find that in our draft at all. In fact, we propose the commission. We propose that a tribunal be part of that commission, because the commission has bigger powers to promote the FOI law, to train officers, to review what is in the list of information should be available. So they have much bigger responsibility. But it has to be democratically elected or appointed, or criteria that is actually put out so people can see that people are being selected based on their qualifications and things like that. So these are 5 areas which, based on looking at the legislation immediately after the tabling, that we are very, very concerned with. It's not in our draft. They have taken out a lot of the fundamental aspects of the Freedom of Information law. And so we think that while it is a very good step, and we really congratulate them for persevering, because there are a lot of challenges, not least the threat that this is unconstitutional, that it is inconsistent with the OSA, which we don't accept, because I think that there are provisions within the Constitution that allows for this, and that because of the way the Attorney General and the state legal advisors are actually structured, they are an impediment to a good law being tabled. So we are very concerned that even though the EXCO has the right mind, has the right, with the right heart, but the good work is actually being challenged, and what has come out is something that does not fulfill what a good freedom of information law should be. So as far as CGG is concerned, we welcome the law, but we are very concerned about what is in the bill, what is in the enactment. We are very happy that they have announced the setting up of the select committee, which is chaired by YB Sari Sungit from Hulu Klang. We have sent him a letter to say that CGG would like to meet up with them to discuss the process of what's going to happen in the select committee, but also with regards to our concerns in the law. And we really hope that they will be open to our recommendations and take our concerns seriously, because we don't want this law to be passed, actually. We don't want this version to be passed by the State Assembly. It really needs to be strengthened in terms of its rights framework, in terms of its processes, in terms of the membership of the appeals board, and basically, just the fundamental principles of what a freedom of information law